Welcome to our identification of the sources of U.S. law. We have seen that code law and common law coexist in the United States and that judges, legislators, and presidents all contribute to lawmaking. What's more, these officials often cooperate in the lawmaking enterprise, interacting to clarify ambiguous provisions in the code law or to apply the common law to more specific situations. These lawmakers collectively create law that is distinct, but they do so in different ways, as we consider in this discussion. In this section, we examine the 5 sources of laws in the U.S. First, the U.S. and state constitutions. Secondly, statutes. Third, judicial decisions. Fourth, executive orders. Fifth, administrative and regulatory law. These sources differ not only in who makes the law, but also in their place in the hierarchy of the U.S. legal system. Moreover, lawmakers create law not only at the national level, but in all 50 state governments as well. So let's look at federal and state constitutions. Atop the hierarchy of the sources of U.S. law are constitutions, the U.S. Constitution and the Constitution of the 50 states. Constitutions are at the highest form of law, taking precedence over all other laws, and they are the primary organizational blueprint for the federal and state governments. Constitutions delineate the powers of the government and the limitations on those powers. They also establish the structure and the function of each of the branches, executive, legislative, and judicial, and define the relationship between the federal and state governments and between the government and the individual. The body of law that comes out of the courts in cases involving constitutional interpretation is known as constitutional law. In cases concerning a provision of the federal Constitution, the High Court is the U.S. Supreme Court, and its decisions bind all Americans, including Congress and the President. If the President or the members of Congress do not like the outcome of a particular case, they may test the Supreme Court's ruling by passing a law challenging the decision. In the instance of state High Court cases, a governor or the state legislature can take a similar action. Legislators and executives also may try to circumvent a court decision by changing the law through a constitutional amendment. For example, since 1963, some members of Congress have sought to blunt the impact of a series of Supreme Court decisions establishing that prayer in public schools violates the Constitution's separation of church and state. These legislators have introduced into the House and the Senate various constitutional amendments that would allow vocal prayer or mandate a moment of silence in public schools. None of those proposed amendments has garnered the 2/3 supermajority vote in Congress necessary to move the amendment to the next stage in the ratification process. Yet some representatives in Congress continue to seek to negate the court's decision by amending the Constitution. Laws written by legislatures are called statutes. Statutory lawmaking is the hallmark of any code law system. In such a system, legislative law reflects the core principles of the government system. For example, the U.S. Code is a compilation of all the laws ever passed by the U.S. Congress, and it reflects that body's priorities and concerns. The U.S. Code has 50 sections spanning a range of issues including agricultural, bankruptcy, highways, the Postal Service, and war and defense. When a judge or a panel of judges decides a case, they sometimes write an opinion that justifies their decision and explains how they have applied principles of stare decisis. These judicial opinions then become part of the common law. Under what circumstances do judges write an opinion? To answer that question, we must consider the resources for appealing cases on the federal and state levels. The federal court system comprises 2 levels of appeals, or appellate court: the Circuit Court of Appeals, previously described, and the U.S. Supreme Court, which has the final say in cases. The state systems generally feature 2 appeals levels, and the final appellate court is the court of last resort, performing much the same function as the U.S. Supreme Court. Judges serving in courts of last resort, that is, the U.S. Supreme Court and the state high courts, almost always write opinions in cases, and those opinions have the force of law. The Supreme Court's decisions govern all similar cases heard in all the federal courts and become the law of the land. A state high court's decisions become the law in that state. Article 2, Section 1 of the U.S. Constitution states that the executive power shall be vested in the President of the United States. This power has been interpreted to allow the President to issue orders that create and guide the bureaucracy in implementing policy. Because executive orders have the force and effect of law, they represent a crucial tool in the President's lawmaking toolbox. Historically, Presidents have sometimes used executive orders to create policy that may not have garnered sufficient legislative support. For example, in an earlier chapter, we described the fact that President Harry Truman's use of executive orders to desegregate the military in 1948 was prudent at the time. A president or a governor can enact an executive order without input from the other branches of government, though executive orders are subject to judicial review and depend on Congress for funding. As we talked about earlier, President Bush used executive orders extensively to address a wide range of issues. These included prohibiting new investment in Burma to punish that nation's repressive regime and improving the coordination and effectiveness of bureaucracies administering youth programs in the United States. In addition to the executive order, presidents and governors have another source of lawmaking power. They had a vast bureaucracy of agencies that have their own lawmaking authority. As we talked about in the bureaucracy chapter, bureaucrats get their power directly from the Congress or the state legislators. By delegating significant power to bureaucratic administrators with expertise in specific policy areas, Congress and the state legislatures help to ensure the effective implementation of the laws they pass. Why specifically must legislators delegate such power? The reason is that lawmakers typically write vague or ambiguous bills. They do so to increase the chances that representatives and senators with differing ideologies will find a given bill acceptable for passage into law. But the result of vague or ambiguous wording might be that the law, once passed, is difficult to implement. Thus, legislators must turn to bureaucrats with expertise and specialized knowledge to help them to administer the law. This delegation of authority gives administrators substantial power. It allows them to act as quasi, which means as if, legislators. In creating administrative rules, implementing them, and interpreting those rules as well, administrative rulemaking fleshes out the broad principles in the statutory law, much of which is interpreted by the federal courts.